Hello, good evening, Elamati.
Good evening, ma'am.
Hello. So, how was the week, Elamati? And did you have a chance to do something on the IPR?
Yes, I had a chance to go through the material as well as take up some exercises in the
Yes.
online as
Physical
well.
on the
Oh, excellent, excellent.
ಕೊಟ್ಟಲೆ 2,500.
And this week we will be posting one of the assignments of the patent law. So, you should probably get it sometime around Monday, Tuesday.
Okay, ma'am.
That will be posted on the assignment on the LMS. So, you can just take a look at it and
Sure.
you can work around.
Okay, ma'am. Is it graded, ma'am? Assignments?
Not really. This will not be graded. So it is just
Okay.
for you to sort of sum up whatever we learned during the last class.
Sure, ma'am. Because I saw last week for the first class, I guess there was some activity posted, assignment kind of thing.
Yes.
So, and I saw an option to upload assignment as well. So I was just wondering, is it mandatory that
Right.
we have to upload, or it's just that it's for our own refreshing or something?
Yeah. So as far as the MCQs are concerned, they will be graded. These
That
are all like practice sessions.
okay.
And then again, you'll have some interim assessments and all that will come up.
Okay.
Yeah. So hello, Saideep. How are you?
Hello, ma'am. I am absolutely fine.
Great.
Upgrading
So,
myself.
good. So I just
I
wanted
wa-
to have a quick follow-up with you guys as to how has the week been and what did you do on the IPR front?
May I start, ma'am?
Yes, please. It's only
Madam,
you. I
I
heard it from
am.
Elamati.
I had got a chance for WIPO certification. So it was a 3-day workshop attended, and very soon I am getting the certification from WIPO
Awesome. Awesome.
uh, for IP and ADR.
IP and ADR. Excellent.
Yes.
So how
So
about our subjects? How about our EBC learning course? How far have you been able to progress?
EBC is excellent. EBC is
Okay.
excellent, but what has happened, as I told you, I am having a list of courses.
Yeah.
My problem, what I'm facing is the assignment. I need a guidance regarding that. Other than that, everything
Sure.
is
You
excellent.
can connect with us anytime. Like I told you the
Yeah,
last week also, right? We can
yeah,
connect with Dr. Anshal anytime and with whatever guidance you require. It's
yeah,
just the
yeah.
MCQs. You can keep taking the video, just watch the video lectures and take the assignments. That's all.
Okay, okay,
It's as
okay.
simple as that. But these will be graded eventually. So you cannot miss out
Yeah,
on this. And June 16th or something, this trimester will end. So you can take
okay.
up as many as possible and just keep progressing, right?
And after June 16th, if I go on submitting the assignments, is it okay or
Just
is
keep
it
doing it. Just keep doing it on the LMS. Okay. There is
okay?
nothing like a timeline there, but just keep doing it.
Okay.
Yeah.
And
That's what I suggest.
On Monday, I am going to have a talk with Madam is
Yes.
there today
She's here,
on.
but I don't know if she will be able to take the discussion forward because she has another call.
Yeah, I
That's it.
don't think I'll have a talk with Madam on Monday.
Yes,
Monday
yes.
I'll have and discuss about the assignments. And Monday
Sure.
I would like to inform you that Monday I am going to get registered as a patent attorney from IP India.
Awesome. Great.
Then after
Fantastic.
that, international commercial arbitration. One course is there for a week. That is around 999. I'm going to do it.
Awesome. Great going. Fantastic, Sadeep. Excellent progress.
But only problem in arbitration, what I'm facing is I'm not getting online works. I have to do it offline.
Okay. But maybe with WIPO certifications and all, you might find some opportunities going further.
Let's hope for the best.
Yes, absolutely. Hello, Kashish. How are you doing?
Yes, ma'am. I'm good, ma'am.
Awesome. How was the week and how did it go with the IPR learning?
It's going good, ma'am, because actually I'm with my parents right now. I live in Delhi, but right now vacation is going on in court, so right now I'm in my hometown right now. So
Awesome. Great. So some time off being with parents.
yeah,
Good. But just keep trying to do something on the
yeah,
learning.
yeah,
Especially the videos and the reading material which has been
I'm
shared,
doing it,
the
ma'am.
assignments. Just keep progressing with it week on
Yes,
week.
yes, ma'am.
Yeah,
I'm doing it. Yes, ma'am.
great. Yeah. All right. So let's get started. Maybe by the time I introduce you all to this wonderful speaker today and, we start the session, hopefully Deepak will join us. So today we have another very, very interesting subject on trademark protection and enforcement. So we have Ms. Gayatri, Advocate Gayatri with us. So Gayatri, we would like to have you on the video as well.
Hello.
Yes. Thank you. Hello.
Hello, everybody.
Yes. So meet
Hello,
Ms.
ma'am.
Gayatri. So I'll give a very quick introduction about Gayatri, and then we'll get the session started. So Advocate Gayatri is a practicing advocate, and she is mostly at the National Company Law Tribunal, Bangalore. Handles a lot of corporate matters, and she is a registered trademark, copyrights, and designs attorney, and she assists her clients with prosecution, IP filings, counter oppositions, replying to objections, etc. So she takes the whole licensing activities and the registration process relating to all of these IP. Her practice areas involve primarily the insolvency bankruptcy code, our intellectual property rights, real estate disputes, and she has represented clients at various courts in Karnataka. So that's a small introduction about Gayatri. I mean, she's given a very brief introduction. She says, my session will speak the whole thing going forward. So I will leave it to Gayatri and she will be sharing her expertise.
Hello, everybody. So happy to be here with you all today. So this trademark registration is something very close to my heart. Apart from the other aspects of legal law and everything, this trademark is my most favorite. Now, coming to the matter at hand, how many of you are lawyers?
I guess
You
everyone.
can unmute.
Actually, all
because we
three
make
are
it an
lawyers.
interactive session.
Yeah,
Sorry?
yeah. Actually, all three are lawyers.
Oh, great.
Yeah.
Wonderful. Even better, because
Yes.
I'm going to get into a lot of common law attributes,
Yes.
sections and stuff. So good. It'll be a good discussion then.
It's going to
That's
be a great
great.
connect, and all of you can just keep your your audio on, and you can have discussions as and when required. So maybe Gayatri will be asking you a lot of questions or interacting with you. So feel free. Thank you.
That will be great, because this session basically it's going to be a very basic session on trademark. I haven't gotten into too much of technicality, because then we need more sessions on this. So we just breeze past what trademark is all about, just to give you a fair idea. But as I can see, most of you are aware of what a trademark is, right? Am I right here? Am I right in believing that you have a...
Yes, ma'am.
Great, that'll be nice.
Yes, ma'am.
So I can, the first few initial slides are all about what is a trademark and stuff like that. So if you have any doubts, I can clarify it at the start itself. So stop me whenever you need me
I think you should
to
just
clarify on anything. Sorry, what was that?
No, I just said please use the chat box extensively.
Correct. I can
And
send the
when,
message on chat box. I'll reply right away.
Asking you, you can just use the chat box and extend.
That will be great. That will be great. Yes. So shall we start?
Yes,
So we're
madam.
going to be discussing about trademark registration, the procedure and the prosecution and the enforcement of a trademark. So now let's come to this very important aspect. Can you tell me what is a trademark? Because I want the session to be interactive. So I'd rather not tell you everything. I'd like to hear from your end what you think a trademark is. Since you've already read through it,
Hello, ma'am.
what do you all consider? Sorry?
Actually, a trademark is a sign or a design or expression of expression that identifies that goods and services of one company or anything like company which differentiate from one and another.
Differentiate from one another. So that is one aspect. Definitely differentiate, underline it, and write it in capital letters. Differentiate. The next aspect, what other aspect do you think makes a trademark? This is a technical definition in the Trademark Act of what can be called a trademark, right? So, which is why I wanted your version of what you think a trademark can be. You're right to a great extent that it is an expression. But expression, what do you mean by expression? It cannot be a spoken word. Is that a trademark? A spoken word cannot be a trademark. it has to be in a physical form. It has to be in a pictorial form. It has to be a word, right? It has to be even a signature. So it can be a name, device, label, numerals. These are all the given, common definitions of a trademark. You can write in the chat box. Are you able to hear me well?
Gayatri, sorry to interrupt.
Yeah.
Deepak ji has just joined us. Hello,
Okay.
Deepak.
Yeah.
Welcome back, sir.
Yeah,
I remember you from the last session.
Yeah.
Good to have you
Actually, I
back.
was in other places anyway. Thank you.
Yeah.
Thank you. Just
And thank
now,
you.
please
Thank you for,
continue, madam.
yeah. That's what. So I was just talking about what can be called a trademark. How can you describe a trademark? So this is a typical definition of a trademark in the Trademark Act. So most important thing of a trademark is it's a physical thing. You have to be able to see it in a pictorial form or a written form. It cannot be a spoken word or a sound or a fragrance. That cannot be a trademark. Those come under a different aspect of intellectual property. I hope you're getting my point. A trademark has to definitely be a physical representation, a graphical physical representation. And as somebody said, you should be able to differentiate one service or product from the other. That is the main important nature of a trademark. That's the only most important use of a trademark. We can't all call ourselves Microsoft, right? We can't all call ourselves a Dabur or a Bajaj. Those are very unique names that make us remember a particular product or a service, correct? So the differentiation part is very important. And most importantly, a trademark, you can't just go and trademark anything and everything, right? End of the day, you should be a proprietor or an individual who's planning to start a business. So either you propose to use that trademark or you have already been using it. Since you're all lawyers, you understand this particular aspect. There should be a futuristic option where you are going to use the trademark at any point, at any time, correct? So it should be used or proposed to be used in relation to certain goods and services. And all these goods and services should be legal, right? That is an important aspect again. So, as you said, it identifies a good or a service. It guarantees quality. The minute you hear a particular word like Tata, right? We have this particular image, this particular idea in our mind that this is a good product. Why? Because the trademark has given it that particular respect in the society. It is called goodwill. You all are aware of the word called goodwill. Now we will be discussing this goodwill, this word over and over again as we go into enforcement and as we go into infringement, where we talk about the enforcement of trademark, right? So are you all able to see the slides? Can you see the slides?
Yes, ma'am.
Under modern business conditions, it identifies the goods, it guarantees unchanged quality, it advertises goods and services, it creates an image of the goods and services, right? We literally have an ice cream called Quality, right? Quality ice cream, seriously, how much more can it create an image in the mind of a person, right? And again, some products have been begun to known by the name of the product itself. Xerox is not a Xerox. It is a photocopy, but we associate a photocopy with the word Xerox, which is actually the company. The product is called Xerox, right? So that's how powerful the trademark is in the normal course of business. Let's move on. Moving on. Okay, now kinds of trademarks. What all can be a trademark? Can people tell me? Can one of you tell me? Anybody here in this group? Can you tell me what can be trademarked? Sorry, you have the slide right there in front of you, but let's forget the slide. If you can come up with your own ideas, that will be great. What can be trademarked? What do you mean when I say trademark? Anybody? You can write your answers in the chat also. Any name, all right? Like Bajaj is a name, it's a surname, right? Tata is a name, it's a surname. They've all been trademarked. Nobody else can use that word anymore because it is there. Not only because it's been trademarked, but because the name itself carries a great goodwill, a huge amount of goodwill, right? So any invented word, any arbitrary word, like can anybody give an example of an arbitrary trademark? Some name, some trademark, arbitrary trademark, an example. Kodak. So Kodak is a Japanese word. I'm sure there is some meaning in the Japanese, but generally some arbitrary word like how about Chilby? That's one of my clients' platforms. Chilby. What is Chilby? It's an arbitrary name. It is a name for a dating platform. But where is the connection? It's an arbitrary name. So chill or Chilby. Yeah, that's how they have the trademark itself looks. The graphic representation of the trademark is two glasses. So that's how it goes about, an arbitrary description of your business. right? Down the line, it may become popular. You never know, right? Like there is this other company of client of mine called Go Desi. What is Go Desi? It's an arbitrary name. Why Go Desi? They sell sweets and snacks and very traditional, like imli chaat kind of thing. They call themselves Go Desi. That's an arbitrary. It's a connection of two words put together, and that becomes a trademark. So that's an arbitrary trademark. Letters and numerals. Any example of letters and numerals for trademark? Anybody? Yes, great. 7-Eleven. That's great. Wonderful. Who was that?
Ilamati.
Very nice. Very nice. And again, the last right to proprietorship of a trademark may be acquired by registration under the Act or by use in relation of a particular goods or service. That is an understood. A three-dimensional sign. Like, what is a three-dimensional sign? Come on. What comes to your mind right away? First example, the McD's guy, right? That's wherever you see that, McD's logo, the three-dimensional McD's, it's put up everywhere, right? That's again a very important representation, a different way of it. Again, sound mark, we were talking about sound mark, graphical. Is it possible to have a sound mark, trademark for sounds?
Yes, ma'am.
So give me an example.
The Britannia sound that comes up in the end of the ad. Or
Britannia song or the Airtel.
yeah.
That sound. Yeah, that sound. That's again the Airtel sound. And Apple, again, they have their own, the Apple ringtone, right? Those are all, they've been trademarked. They've been registered under the designs. So they are fancy symbols, devices, monograms, right? Combination of colors. Any examples for combination of colors?
Cadbury.
Cadbury. Very good. Well done. Cadbury. Again, the deep blue, that color of Cadbury. That is, of course, shape of roots or their packaging. Very, very recent product. I'm sure we are all using it in our houses. ID, they came up with a zip pouch. Idli batter. So they have trademarked that packaging. Yes?
Maggie.
Yes, again, Maggie. Right? So great. So then what are the other types of trademark? A product mark, service mark, collective mark, certification mark, shape mark, sound mark, and pattern mark. Pattern mark, you understand, rest everything is self-explanatory. What's a pattern mark? Any examples of a pattern mark? Hello? Nobody? Okay, what is a pattern? Coming to pattern, what is a pattern?
Which has a sequel of design.
Yeah, like a zigzag or a circle or, yeah. What do you think is the most common pattern mark? What comes to your mind right away? Pattern? Audi, right? Audi? Concentric circles. Yeah, the trademark of, right? Any doubts here? Any questions? Shall we move on? So when we go ahead to register a trademark, the first thing that we have to decide is what classification, the trademark classification, our products will fall under. What are the classifications that they will fall under? So there's something called the NICE classifications. You go on the website. I'm sure all of you have done it so far. I heard somebody saying that I went to the IPR website. I was doing some research. I just heard somebody say that. So you have to go to the NICE classification, or it is there on our Indian IP India website also. The trademark classification details are there in the IP India website. You need to go there and find out under what classification your product or service falls under. So, for example, classification of goods, you have classification of goods and services. Goods will fall under classifications from 1 to 34, and services will fall from 35 to 45. The last 10 are left for services. So what is the difference between goods and services? How do you differentiate between goods and services? What are goods and what are services?
The products which are sold in retail is goods.
Yeah, physical products that you bring home, Britannia, like you said, Cadbury, Britannia, cards. Yeah, all of those are goods. What are services? Like trademark classification of the, sorry?
Activities or benefits provided by some entity.
Yes, services provided by some entities like software services, like apps on the internet, right? Most of the time, apps come under products too, because you're buying those apps physically. But the process of making those apps will fall under services, under class 48, 38, 42. Will all fall under different classes. The process of making the apps, those are services. Like legal services is a service. That is also a service, right? Teaching is a service. So all of that comes under from 35 to 45. So once you go into the classification site, it is all given there. So, but this you need to find before. Why? Why do you need to go into classification of goods and services before you register a trade? The simple reason that you need to know under what trademark class you need protection under. See, either you protect your trademark under a single class, or you go for protection against several classes. Most people, in my experience, go for multiple trademark classes, right? They do not go for a single trademark, because as many classes as you can get, under your umbrella of protection, that will be the best. But of late, I'm seeing that the trademark registry is granting a single class registration faster than a multiple class registration, because I think there are some issues there, because the more classes you get into, the more people you are pitting yourself against, right? So it's just by experience, that's all. It's not like it's a done thing. But generally, as a lawyer, I would counsel my clients to go for multi-class registration, but most people are preferring to go for single class registration of late. So multi-class registration falls under a different class that comes under class 99. So if I want protection under class, uh, like for an app, for example, if there's an app, again, Chill Beach, one of my clients, if they want protection under trademark, I have to take a protection under goods also and under services also, because it's a good. App is a good, but the service that go behind the app, again, that comes under classification of trademark servicing, the service class, right? So you need multiple class of registration there. Any doubts? Any questions? Okay. The most important thing before you start, after you have found out what class your trademark will fall under, right? What is the next step? What is the next step? Anybody?
Registration.
Not registration. Before registration, you need to find out if your preferred trademark has already been registered, or is it already available in India or outside of India, right? That's important, right? You need to find out. You can find a name that's very, say, Air India. You can't register Air India, right? Correct? You need to find out if your trademark is already up there, if somebody is already using your trademark, whether it is available for you for use. Like when you go for a domain registration, it will tell you that this is available, this is not available. You cannot go and register any domain, whatever you will and wish, right? The same for trademark. You need to find out if this trademark is available for registration. So where does this come? This public search of trademark comes into picture there. So you can go to the IP India trademark portal, and you can go to the public search of trademark, and this will give you all the trademarks that have been registered in India. Registered, and all the trademarks that have been applied for. You can find out if there are any applicants also. There could be a trademark that has not been registered yet, but there may be applicants whose trademark has been objected to or opposed to, right? It could be any of the situation. But the first important thing is you have to go to the public search and see if it's available, right? So you go to WIPO search, right? World Intellectual Property Office, there, or the IP India online search portal. If you are only planning to register your trademark in India, in the geographical area of India, then this is enough. IP India is more than enough. But if you're going for WIPO search, then you'll find out internationally. I'll come to international trademark again. The international trademark registration, the most important thing about an international trademark, if I am a trader, a business person in India, I have a business online. It's there. My website is there. It is being used by many people all over the world. Can I apply for a trademark in USPO office, USPTO? Is it possible for me to apply in USPTO? Although my product is on the net, it's on the World Wide Web. Can I apply for a trademark
Yes.
in the USPTO?
Yes.
Yes?
Yes, if the product is being shipped, technically speaking, just because not I search it and I find it not, but I should be sold there. People should be able to buy from US.
That's a good answer, but there is a hitch here. You need to have a representative in that particular geographical area. That is when you can go approach a USPTO or a EU, you know, European intellectual property or anywhere in the world. You need to have a representative, either an office or an agent who's going to be handling all your matters there. It is not enough if you have online presence, not good enough. Whereas in India, they apply. They can come and apply in India. Their online presence is enough. But again, as you said, the product is sold. There is an agent here. An agent has to be in that particular geographical area for you to be able to apply in any of these places. I think it makes sense, right? You have to be there. Your presence needs to be there to give a local office address. Do you agree with me? I think in this today's time and days, it doesn't make any sense to have this particular rule that you need to have a local presence there, an office or an agent. But that's how it is. I think it's high time they can change it, because most of these platforms are like out in the, for all to see and use. Any questions? Moving on. So if you want, you can take a short screenshot of this. This is the general process of filing a trademark. You will find it in any textbook or any portal you go about how to file a trademark. So first, how the process of registration goes, right? You can take a screenshot of this picture because it tells you in a nutshell what goes behind trademark registration. What happens? Can we proceed? So the first step in trademark registration is you need to file an application. Very simple. Trademark application or TMA. You go to the trademark portal and you'll find all of this. The TMA is there for you to start. So you file either that's what you decide the class. So you have to put in the class first, feed in the class, and then you go ahead and write the proprietor's address, blah, blah, blah. You have all the procedure that happens there. So before that, you need a few documents, important documents that should be uploaded on the portal. So what is a POA? All lawyers on the group, you know what a vakalatnama is. So power of attorney is basically a vakalatnama for a trademark attorney to file your trademark on the trademark portal, right? You need to have some a power to represent your clients, right? You can also file a vakalatnama. That's also done. But there is a format, the trademark TM48. It's called the TM48, right? It's a vakalatnama. Basically, it's a vakalat. The TMA is a trademark application, and the user affidavit is like any other affidavit that we file in a court stating that I am so and so, I live in this place, I am the son of this and that, and this is my company, and this is my product or service or whatever. I have been using this trademark, or I'm planning to use it for this time and that time, whatever. You don't need to give a date, of course, if you're proposing to use it. But if you are using it, you need to give a date of when you started using, right? So far, so good. These are the documents. What are the documents? A vakalatnama or a power of attorney, which is called a TM48. And then you have the TMA, the trademark application itself. Trademark application itself consists of the application which has a description of the word or the product or whatever, the nature of your business, the nature of your trade, nature of the product, and also a description of your logo or the trademark itself that is going to be applied for registration, right? And under additional, there's something called an additional representation that would be under the TMA, where you would talk in detail about your trademark itself. Yeah. A POA, you need to take it out in a non-judicial stamp paper, right? Lawyers, I'm sure you're aware of what that is. And the best part is in a trademark wakalatnama, you don't need to get it attested by a notary. Self-attested document is enough. Signed by the client is more than enough, good enough. You don't need an attestation from a notary, right? Use an affidavit, again, self-attested affidavit is more than enough. It's sufficient. You don't need to get it notarized. Of course, if you're a company, a seal would do. A seal would be very nice. It would be great if you have a seal. Just seal it and send it, right? And you know what the deposition is. You're all lawyers, so I don't need to go in detail about what a deposition by the applicant is. Verification and deposition, you're all aware of. Common jargon of a lawyer, right? So TM application, you have the title of the trademark, the logo, the nature of the product, trade services, the nature of the trade or the services, class details, of course, the description of the logo and additional descriptions of the trade. Anything extra you want to say, like the color, the smell, the whatever, something that is very unique to your logo or the trademark that you talk about, right? Now coming to trademark agent. Somebody is going to become a patent agent tomorrow. Congratulations. I just heard in passing the conversation. So it is similar to how you write the exam for a patent agent. Here you don't need to write an exam. It's the best part, the trademark agent. You go to the trademark portal. Pratima, do we have time to go to the...
Yes, but like really quickly.
Really quickly. That's what I thought, because...
Stages or just share the forms with them, how it goes and other things.
Yeah, very quickly. I'll just show them. See
Maybe
this.
Gayatri, if time permits, maybe a quick method of trademark search would really be helpful.
Trademark search, right? We can do that. Maybe I can give them
that interest everyone. Yeah.
That will be great. Would you all be up for it, people? Can you all go to the public search portal?
And Gayatri, you can just post the link on the chat.
Okay.
So
I'll do that.
I'll do one small activity here today. Let's do a trademark search. Okay.
Okay, that will be
all
great.
of you will just go to the link that Gayatri will be sending now.
Just a second. Just hold on.
Get to the link and let us know once you are done, once you have onboarded on that link. And Gayatri will guide you through how to go about with a simple trademark search. Gayatri, you can just probably get to that screen also.
Yeah, I'm just going there. So let's do a public search of trademark in India. Right?
I'm just curious to know, have anyone done this before? The participants? Anyone who has done a trademark search?
Yes, ma'am. Ma'am, I have also done, ma'am.
Awesome.
Oh, that's great. That's great.
Oh, that's fantastic. Let's just try doing that once again or something for the benefit of everyone. What about Saideep and Deepak ji?
So, yes.
And last time Deepak ji and we went through the whole public search of...
yes,
I remember.
Yes.
What about Saideep?
Sir, madam, done. WIPO, USP2, IP, all done.
Oh, okay. Then,
wonderful. Then do we need to go into it, Pratima?
Yeah, not necessary, I think. If
not necessary, ma'am. You can skip it. You can skip it.
Skip actually. Yeah.
That's what I thought. They've already done this.
Part of it.
That's great. That's wonderful. So then what is important is that you need to look at these documents then. That will be more important. Can you see is there any question regarding the documents that need to be filed while registering a trademark? Anybody?
Madam, can you explain this one if you don't mind?
Which explain?
This one, man. Documents for relevant documents, preparation of relevant. Alatnama is okay, understood. And PO is also good. and TMA, that's also understood. Regarding the
Hmm.
user affidavit, regarding that, I need a
Uh,
clarification.
See, affidavit, it's like a very standard document. Sorry, I didn't get your name. Sai Deep, right?
Yes,
Uh,
ma'am. Yes, ma'am.
yeah, in any court of law, if you're filing an application, a petition, or whatever, you need to adjoin an affidavit, right? It is similar. This affidavit is
Similar
a
to
very
that.
standard, similar to that. It's a very standard document
Okay.
that, see, you just state the name of the person. I, Gayatri, a citizen of India, staying in Bangalore, this in this address.
Yeah, got it,
Is a
got it,
daughter.
got it,
Yeah, it's the
got it,
same.
got
It's an affidavit. It's any like any other affidavit. No other change in it.
it. Like the normal affidavits filed in the court, signed by the
Absolutely.
deponent.
It's much,
Okay, okay.
it's not so elaborate, actually. It's not all that elaborate. It's just a one-page document that just
Yes,
states
yes.
4 or 5 points about who I am, what my business is, and what is my logo, and when am I using it, or from when I am planning to use it. That's all. Very small little affidavit. And then you have the verification of the
Contents are
yeah,
true and
deponent.
correct.
That's it. That's it. It's a very standard
Got it, got
document.
it. Got it,
Yeah.
got it. Thank you, ma'am.
See, affirmation of usage, those are the terms and the clauses that will fall in an affidavit, right? So this is the format of a TM application. You can take a screenshot again. So this is how the format will flow. If you look at it, you will have the title, the logo, the nature, class details, description, and additional description, right? So this we can move on, right? This has been done. You all have a digital signature, I'm sure. Have you procured a digital signature yet? So there's something called eMudra, where you can procure a digital signature from them. Class 3 digital signature, specifically a class 3 digital signature, which most of the time is very easy to install. You need to have this JavaScript and all that. You can help, they will help you. Actually, they are very, very helpful. Please approach eMudra people. They help you throughout. That's how we all went through our digital signature installation and stuff, right? Because without these days, of course, e-signature has also come. So they've made it a lot more easier. In the good old days, before this digitization of the trademark portal and all that happened, we had to go and submit all of this in copies of 4 or 5, like a good old court. Three original copies and one for the other, myself and the registrar and all of that. 5 copies you had to go and submit physically. So thank God for the digitization of the trademark registration process. All of that has been done away with. So you just need a digital signature and you're all set to go, become a trademark agent or an attorney, right? So now you've gone and registered your trademark. All well and good. You've procured your digital signature, your trademark is registered. What is the next step? What is the next step? What do you think is the next step? Anybody? Approval, not approval. The next step would be, acceptance from the trademark. Same as in a court of law. A suit can be dismissed if they don't find grounds. Same here. If they don't find it worthy or original, they will refuse, right? They will refuse registration of trademark. So what are the grounds of refusal? What are the common grounds of refusal? You have one under section 9, most common grounds of refusal, these are all. Okay, section 9, section 11, section 10, section 13, 14. Now we'll go in detail about these sections. Section 9, absolute grounds for refusal. They say, no, not done. This cannot be done. Why section 9? Under section 9, what can be said? Because it lacks distinction. It sounds exactly like some other trademark. Charminar, no, you cannot go and say Charminar, but there is a cigarette brand and stuff. But yeah, those are all like exceptions. But yeah, there are absolute grounds. You cannot have a word that says Mera Bharat Mahan, not done. You cannot go and register. Tell me, give me some examples. Let me see what you can come up with. Examples of refusal under section 9. Something that screams of, non-distinction. It is not at all distinctive. Anybody? Some similar names, like what similar names? Coca-Cola. Cola, yeah. Cola. Not like that. What I'm trying to say is, a very well-known, you cannot have a product called Mahatma Gandhi. Can you go and register the name Mahatma Gandhi in a trademark portal? I mean, that is like Section 9, straight away. Gandhi also. You can't go and register Gandhi, right? Like some examples, some more examples of a very common name that that doesn't have any distinction. Many times you cannot name the product. You cannot call rice. Simple. India, Bharat. You cannot call if you're selling rice, you cannot go and trademark the name rice. You can't say trademark the word pony rice, right? You can't do that because these are all generic names. Generic. You cannot call your product what it is, right? You can't call tea. That cannot be trademark or registered under the portal. You're getting my point? If you're still confused, I can come up with more examples. You cannot call a coffee brand coffee. Coffee can be there, but it has to have another unique name, like Third Wave. Does it have anything to do with coffee? Why Third Wave? Right? Starbucks, that will come again. Starbucks, we'll talk in detail about Starbucks as we go through the other slides. Got it? Can we move on about this section? Section 9 is clear. Are we clear on section 9? Can I move on?
Yes, ma'am.
Yeah. And section 11, it should have, see again what you said, it shouldn't have any relative similarities. Like, for example, what Microsoft, you cannot call your product Microsoft. Yeah, it shouldn't sound similar to another product. Section 9 is product cannot be generically named, right? That is what section 9 is all about. It lacks distinction. Whereas relative grounds will be like, in case in India, there is, what are the very popular brands in India? Very, very popular Indian brands, right? You have Bajaj, Dabur, anything else? Tata, of course, we've already discussed, right? Any other examples like Coca-Cola, yeah, Tata? These are all like very common names. Microsoft is a very, very common example because most software companies will have something like micro or soft or software systems or something. So in between Microsoft, they have this IP or IPR watchdogs in their companies. They immediately they are looking all the time. The minute they see system or micro or soft or anything, they catch on to it and they'll get after you. A a recent example, again, this is one of my clients. I was talking about Go Desi. Our logo is Go Desi. So who comes after us? Govardhan Dairy. The Govardhan people, Go Cheese, right? So they have trademarked the word Go. So the IP watchdogs came after us and they said, you can't have the word Go. But then when you look into the trademark portal, there are like umpteen number of products that have the word Go, not just, Govardhan. So of course we did get our product registered, but this is a very interesting case law that I would like you all to go back and look into, if possible. It's there on all the websites, right? Moving on. Section 10, again, limitation as to color. Can you have a tricolor as your trademark? We cannot keep a tricolor, right? Those are all limitations. Again, DMK is black and white, and some other Congress is, again, the particular color of you cannot use their colors. They can come and sue you tomorrow. Not just companies, even political parties can come and sue you. Anybody whose color you're threatening, trademark color that you're threatening. Those are also like, and section 13, you cannot register chemical elements. Yeah, you cannot call your trademark hydrogen or oxygen or something. But there are trademarks that have been using these chemical names too. Any examples of a trademark, a chemical name of a chemical product? O2, right? Yeah, got it, folks? And this we discussed, section 14, use of names and representation of living persons or persons recently dead. Right? Abdul Kalam, no chance. If you want to use that name, you need to get an approval, prior approval from the people who are in charge, right? Now, what is section 12? Section 12 is that particular section that allows us to be able to register a trademark by way of concurrent usage. For example, my client who has been using this particular trademark for the last 10, 12 years, the minute I say this word, like if you're a Bangalorean, you'll know MK Retail, right? If you're in Bangalore, you'll know this chain. Again, some common chains that are there in the general parlance. So those are all protectable under section 12. So if you can prove that your trademark has this particular aspect of concurrent usage and other special circumstances where you have a goodwill for the trademark, people immediately they remember. Like there are MTR is a very common name in Bangalore. I'm sure, I don't think they have a trademark. I haven't checked yet. But they don't need to trademark your name because they have the goodwill. You cannot go and start an MTR and say MTR. What is a very common deception? In Tamil Nadu, there is this chain called Saravana Bhavan. Okay, hotel chain called Saravana Bhavan. 90% of the hotels that you see on the highway are called Sri Saravana Bhavan. The Saravana Bhavan, they have found variations to use these trademarks. I think Saravana Bhavan is just overlooking all of these aberrations and infusions. They haven't filed a case on all of these restaurants so far because they are not the original Saravana Bhavan from, Chennai. But you can see 101 restaurants on the road with the same name, but with a slight twist, They'll just have a different way of writing the script kind of thing. How many people can you go and close down? But people know and they see what is not original. So now so before we go into a registered trademark, once you go into the registry, your trademark is refused. So you have to file a reply to the objection. All right. That is again a big process. It will come back to you as an objection from the trademark registry. So once you filed a reply to the objection, right, they will publish your trademark. Okay. Once the trademark is published, that is when it comes to the knowledge of every other person who is in the IPR watchdogs. They all find out, okay, your trademark is up here for registration. Then you come for opposition. You'll come up for opposition, right? Whichever party owns that particular trademark, they will oppose in the trademark portal itself by a particular form in the trademark portal that is called the TMO. So you go to the trademark portal, there are several forms. I really don't have time to cover all of this today because I'm just giving you a basic idea of, how to register a trademark. So either there can be an objection from the registry itself, or they can be an opposition from an interested party who has a similar trademark, right? That will be called the opposition notice from the trademark registry itself. So all of these circumstances you can handle in the trademark portal itself. They will call you for a show cause hearing. Okay, not in the civil courts, not in the magistrate court, but in the trademark portal. It is an online hearing. You can go in person or you can appear online by a video conference, where you can go and tell them that state your case, like in a court of law. It is very similar. There is no difference. There you're talking to a judge, here you're talking to a registrar. That's all, a sub-registrar. Get it? So that is the second process. First is an objection, second is an opposition, right? Now, we are coming to a registered trademark. Now you've registered your trademark. All of it is done. All hunky-dory, well and good. Now, what is the problem? You're seeing a Sri Saravana Bhavan, the Saravana Bhavan, my Saravana Bhavan, correct? What do you do then? What are your options then? What are our options? Anybody? Because now you can't go to the trademark portal because your trademark is registered. The trademark portal is out of the picture. They have nothing to do with this anymore. You have your trademark, which is registered, and then you see this trademark being used by somebody else. Again, another case of one of my another client of mine, Gokulam. Gokulam is a very common trademark. Remember, if you are an old timer, if you were born in the 80s, you know there used to be a Gokulam tooth powder. Anybody? In Tamil Nadu, of course, down south. So they had to file an infringement on that. Sorry? Yes. We'll get into common law aspects. We'll come there. So these are the, sorry, man. So infringement and passing off. Now coming to infringement and passing off, there is a very stark difference between these two aspects of, oh, sorry, I don't know what's happening. So what is the difference between infringement and passing off? Anybody? Quick answer. Mr. Saidi, what is the difference between infringement and passing off?
Madam, is it okay if I answer on the mic?
Yeah, please. I just want
Madam,
it to be an interactive.
infringement means someone taking my trademark and infringing it, using the trademark without my
Correct.
permission.
Infringement, passing off is all the same. Somebody's taken your
Passing off.
trademark. Like I told you, the very common case of the Saravana Bhavan and even Kamath hotels. Kamath group chain of hotels.
In Hubli, there
What is
is
the difference
one.
between an infringement and a passing off? It's very, very fine. There's a very fine difference.
Passing off, giving up, let it go.
No, not at all. Both are similar, Mr. Saidi. Both are similar. Infringement and passing off are both the same, except for the fact that in the case of infringement, your trademark is registered, right? So you have a registered trademark in your hand, correct? So what do? You go to the court and say, I have a registered trademark. They're doing this to me. They're using my trademark. You ask them to stop using it, correct? You have a statutory remedy there. Whereas you don't have a registered trademark in passing off. Your trademark is not registered. What do you do then? It's just a name that you've been using for MTR, for example. MTR, if they have not registered their trademark, somebody else is using, what do? They have not registered. In the case, the trademark has not been registered. I don't have a remedy under the Trademark Act.
Will they go for passing on?
Yes, they have a remedy under common law. You have stated the section there. See, that is the section that is applicable for passing. But this will go to the civil courts. It will not come to the trademark registry. Correct? It will not fall under the Trademark Act. It will fall under the civil procedure codes. Okay, there are remedies for infringement and passing off. But what are the difference? What is the difference? The registered trademark. This trademark is not registered, but I have the goodwill. I'm sitting on the strong name that has been built over a period of, several years that I'm using it. I cannot let anybody else use it. For example, 9 yards. 9 yards is a very common word that is used for a starry. Again, that's one of my clients. They said you cannot register 9 yards. Then there is another 9 yards. But since we had a constant use, recurrent usage, we got the training. So we could file for infringement in the trademark portal itself, and we could stop them from registering the trademark, the name 9 yards and the trademark portal. So we had the upper hand at that point, right? Are you getting the point? The third important aspect of passing off an infringement is that in the case of infringement, you can say, see, this is 9 yards, I have 9 yards, they can't use it. I don't need to prove anything else. I can just say it's similar, just take it out. Whereas in the case of passing off, I have to prove my goodwill. I have to say, I have this, I have that, I have all of these people who know me. And I have lost so much of business because of this. So this will become a civil suit in the case of passing off. Any questions here? This can be handled in the commercial court, right? Passing off cases. You can go and we will look into the other remedies. Got it? So enforcement of trademark, you have civil and criminal remedies. And since you're all lawyers, I'm not going to elaborate on this. If you need me to elaborate, please tell me. I'll stop right in there. Right? Got it? Do you want to come up with what are the remedies that are available for my clients, for your clients in future? Anybody? What are my remedies, civil remedies, as a lawyer?
Madam, take an injunction under Order 39
Injunction.
Rule 1.
Injunction. Very good.
Expert
Very good.
ad interim injunction.
Very good. That's our best tool, right? Being a lawyer, first thing we go for injunctions. Suit for infringement, a suit for passing off, injunctions. Of course, we sue for damages and costs. We ask them for accounts of profits, right? All of these are very common legal jargons. I don't need to elaborate on them, right? Right? Can we move on? Anybody has any questions? Okay, criminal remedies. Coming to criminal remedies, what do you think are my criminal? What is the difference? What is the difference between a civil remedy and a criminal remedy? Hello, lawyers in the group? Anybody? Police complaint, yes. File a complaint to the police, the magistrate. Go to the magistrate court, file a complaint. Immediately you go file an FIR and say not an FIR, it's a complaint. Saying that, see, this person has infringed my trademark. He's putting it up and this is a problem and I want him to stop doing this. If there is prima facie evidence, the police can go and tell him to remove the trademark, right? Like, for example, if my restaurant is here and the other person's restaurant, they start a restaurant right opposite to my place of work and call it something similar. I have every right to complain, file a complaint to the police and ask them to take off the signboard and ask them to stop using it. Immediate. And the second part is destruction of the evidence of usage of trademark. That can also be done. The nameplate can be taken out, right? Is it available to me? Is it available to a trademark owner? Registered trademark owner?
Madam, may I answer the criminal remedies? Because
please go ahead.
Madam, in civil remedies, you can go for a injunction. Similarly, in criminal remedies, you can file a police complaint. If
Police
the
complaint, yes.
Yeah, I would like to explain a bit detail. If the police are not ready to register the complaint, then you can approach the magistrate court and register a complaint
Magistrate. Correct.
taking a directions. And after that, file a criminal case and run it or file a case before the concerned authorities. For example, if someone is running a bar, I would also like to give example. I am having a hotel. I am having a hotel in a good location where everyone is vegetarian. It's a just example, and they are non-drinkers. So someone comes with a bar and restaurant, and the people in the locality start objecting. Then we can file a police complaint or go to the magistrate and file a complaint before the
See,
excise
secondly,
department.
you're right, Mr. Saideep, all of this is very correct. But this is not even related to trademark. This is common tort, right? It falls under common tort. Yeah, it doesn't even fall under trademark.
Can be stopped. But what
Yeah,
happens?
definitely.
The trademark
This
proceedings
is a
will be
process.
stayed.
This is a
It will
process.
be
You're
stayed.
right.
Yeah.
That is correct. You got it right. We have another instructor in the group. I'm so happy. We have another lawyer.
I have done my paralegal. In paralegal, what has happened from Law Chico, I have done some US works what you say, USPTO. I had got a project on USPTO.
Very good.
Trademark research on USPTO, then WIPO, then PTO, USPTO, UK PTO, and IP India. These were some of the projects which I have done. And regarding
Very nice.
there's something, DCMA Act, that is also there, 1996, I would like to tell you. So under that, putting down the putting down the business by giving a notice under the I don't remember the full form, DCMA Act 1996. You have to draft notices and tell them that so and so you have infringed so and so thing, and you have to shut down the business. I am not so I can't elaborate too much because of the lack of
That
time.
is why I'm not getting into all of those aspects, Mr. Saidi, because we'll need 2-3 sessions if we get into all of these aspects. I'm just giving you a basic idea of what can be done, the civil remedies and criminal remedies. As you said, police complaint. If police complaint is not possible, then you go to the magistrate and get directions. Finish. End of the criminal aspect of it. Rest everything, if we have to talk, we need, as I told you, several sessions, right?
Yeah, that's
Yeah,
true. Madam, where
yeah.
you practiced in Karnataka? I am also from Karnataka.
Oh, great. Which I have my own office, GV Law Associates.
Okay, is it in Karnataka or
Of course,
Delhi?
I'm in Bangalore. I'm placed in Bangalore.
Okay, okay.
It would
I
be
am
great
also
to meet
planning
you.
for
Why
a
don't you?
IP. I am
Sorry?
planning for a IP I am also planning for a IP litigation, so I needed some
Absolutely happy
IP.
to help anytime. You can take my address from Pratima and you can connect
Yeah,
with me on email also. I'll help you with whatever you need. I'll help you with all of your
I am
queries
also
also.
having a WIPO certification
Oh, great, great,
done.
great.
It's about to arrive.
Oh, great. Wonderful, wonderful. That's great.
I
So
won't
moving on.
give you the list. I won't tell the list. The list is very big, so we'll connect later and discuss it.
That's what we'll discuss it.
Okay.
Yeah, I'll discuss it. And at
This is
another.
not a proper platform right now.
Absolutely, absolutely, totally.
Okay.
So other remedies, border enforcement, counterfeiting measures, anti-counterfeiting measures. These are all like common legal jargons. I'm sure you're all aware. Should I elaborate or should I move on? Any doubts here? Yeah, the last is, of course, the digitization of the trademark processes, which has made it so easy for many people. You don't even need an agent or an attorney. Most people are not aware, but it's a lot of paperwork, so they prefer to go with an attorney or an agent. But anybody can go to the trademark portal and apply for a trademark. They don't need an attorney basically or an agent. But yes, when it comes to handling all of these legal hassles, it's better to have a lawyer at your end. So you can sleep tight in the night without any, stress or tension. So coming to the popular trademark infringement case laws, I've taken up only the most very popular landmark as per, the common knowledge is Yahoo India and Akash Arora. I'm sure all of you are aware of this case, right? I don't need to elaborate on this case. Can I have yes, go ahead. And anything? Are you all aware of this Yahoo case?
Yes, ma'am.
Um, Mr. Saidi, we will discuss in detail on the charge for filing trademark. Yeah, you can connect with me. I'll give you my email ID. We'll connect. I'm sorry, who was that?
Ilamat, ma'am.
Helen. Yeah. So we'll proceed, right? Yahoo Inc. All of you are aware the Yahoo case on Akash Arora. Yahoo filed a case in India against Mr. Akash Arora because he had started a portal called yahooindia.com at that time. In 1999, it was something unheard of in India because we didn't have any section in trademark that spoke about online registration or domains. There was no mention of domains at that time because we were all, internet was something new to us. It was like a magic, it was happening. The magic was happening in those days. Email and everything had just come to India. And Mr. Akash Arora, he started this company called Yahoo India. So they filed an infringement case against him. And they could stop him. They got a permanent injunction against Mr. Akash Arora. He couldn't continue with this business. So this is a landmark case because the word domain itself was unknown in those days. And then the courts of India, they were able to differentiate between what a product is, what a service is, and what an online presence of a particular trademark is. That's when this online internet blah, blah, blah thing came into existence after this case. So then even the domain names cannot be the same. That is when all of this confusion happened. And this was the time that Y2K, remember? The Y2K confusion was going on around that time. It was like interesting times, very interesting times. And again, all of you are aware of this case called Miswak. I'm sure we're all using Miswak in our homes, or at least you've seen the Miswak paste. So Dabur had the Miswak paste. And who came up with the same name? Bajaj Herbals. They said Taj Miswak, some other, like they called it something, but Miswak, again, is a generic name. It's the name of a herb. First of all, Dabur itself shouldn't have gotten the registration for Miswak, but they registered the name Miswak. And then they went around saying Bajaj cannot use it. They cannot use the word Miswak. But unfortunately, yeah, the registry said yes, Bajaj cannot use it. They were um, uh, given a permanent injunction in that matter too, right? Any other case laws that you want to discuss, people? Any other case laws that you have come across? Anybody else? Something that you've heard? Again, my clients go Desi and Govardhan, 9 yards. Those were all like similar. We got opposition. It was accepted by the registry. When they published it, we got oppositions by way of trademark owners and trademark applicants also, right? So moving on, finally finishing with a funny anecdote here. Starbucks Coffee filed an infringement suit on Sardar Baksh Coffee in India. It was deceptively similar sounding because apparently Indians cannot say Starbucks coffee. It can sound like Sardar Baksh also. Yeah, in the Indian tongue, the English word can sound like this too. And you've seen the logo of Starbucks. It's a woman with a crown with a flowy hair. In the case of Sardar Baksh, it was this man Sardar with a topi, Sardar ka jo pagdi, and with a long flowy hair and all that. So the logo was also like very, very deceptively similar. So yeah, they were granted an injunction, Starbucks. They couldn't use the logo afterwards. They had to change the logo. So just finishing on a funny note. That's all. So that's about it. Any questions, please? The floor is open for questions. You still have 15 minutes.
Ma'am, actually, what is the difference between Section 9 and Section 11? It's, I think it's talking about
Section.
the same thing.
No, not at all. Section 9, as I told you, if a particular trademark lacks distinction, like it should be distinct. What do you mean by distinct? It shouldn't sound like as I told you, it shouldn't be generic. You cannot keep the name of the product itself. Correct? Are you getting the point? I told you, like you cannot call the product that you're selling rice, or you cannot call your school just school and say I'll trademark I want to register the name of the school as school. Because school is a generic word, right? That is Section 9. You cannot use the name of the product or service itself. And it should sound different. It should sound arbitrary. Section 11, the difference between Section 9 and Section 11, Section 11 is about two products sounding similar, two names sounding similar, like the Starbucks and Sardar Box, right? That is Section 11. Whereas in Section
So
9, I
Gayatri,
told you, like Gandhi, Mahatma Gandhi. Yeah. Yes, Pratima?
yeah, so Gayatri, probably I'm just trying to understand the section 9 and 11. In case of section 9, it's like an absolute no. You cannot
Absolute
register
no, no.
those marks. You make some changes
Absolute
here
no,
and
no.
there.
There are
But
some
in
ways.
relative, yeah.
Yes. Carry on.
In relative grounds, if you are to make certain changes as per the directions of the trademark office, maybe there is still a possibility for us to be
Even in
granted.
Section 9, Pratima, even in Section 9, the minute they raise a Section 9 and they say your trademark lacks distinction, any distinction, or they will raise an objection. In many cases, I have received a Section 9 objection in many cases. It is not like it's an absolute no. You have to find ways, find loopholes in Section 9 also. There are ways to find loopholes. Like Agro Bharat, the other client of mine, the Agro Bharat, they said it sounds like a government organization, Udyog Bharat, Agro Bharat.
Yeah.
You cannot have Agro Bharat and Udyog Bharat as a trademark. But we were able to find some loopholes in the general system. So that's how it works. Section 11 and Section 9, see, it shouldn't sound like, as you said, India. It shouldn't have the word Bharat. It shouldn't have the word Abdul Kalam, right? Whereas in Section 11, it shouldn't sound similar to another product that is already existing. That is the difference between Section 9 and Section 11. It shouldn't be similar to an existing product under Section 11. Got it, Ilamati? Are you clear on that?
I think it was Kashish.
Yes, ma'am.
Kashish, I'm so sorry. So sorry. Yeah. Is it clear now, or should I elaborate on that?
Yes, ma'am, it is clear.
Okay, great.
I think Saideep has raised hand. Please go ahead, Saideep.
Madam, today I had been to some Reliance Trends. There I saw that Jio Bharat, something like Jio Bharat was
Hmm.
put.
Hmm.
So as you are saying that Bharat cannot be used as a
Correct,
uh,
correct. You cannot. They would have received, if they were trying to register the trademark, I'm sure they received a Section 9 objection from the trademark. 100% they would have received it. And I'm sure they found some loopholes in the law and in the way they formatted their objection reply. See, all of this, that is why you need a lawyer to file your trademark. Why do they come to us? So we can find the available, loopholes as you're filing a trademark. If it were not for the objections that the registry is going to raise, or if it was not going to be the opposition notice that is going to come from any other opposite party, you don't need a lawyer, you don't need an attorney, you don't need an agent to file your trademark. Why are we here? The middlemen here. So we can help our clients with all of these, pitfalls during the course of filing or registering a trademark. Geo,
yeah, and
of course,
also
I don't see any other geos. I haven't seen many other geos. Not
now
many.
they are what you say, Jio Bharat payment app and some credit cards they
Hmm.
are doing.
Hmm.
And while you said Bharat Pay, that's also having the
Correct,
name.
correct, correct, correct. You cannot use these words. What I'm saying is, I just gave it for an example, like India and Bharat. That way, you have so many companies that are using India, right? Tab India, hello, for crying out loud. What are we talking here? There are loopholes. And again, if you are filing a trademark, end of the day, it is not just a word. Most of the time, you're also filing a logo and a caption, and it is all sight, right? Sight and remembrance and all of this plays a very important role when you're filing a trademark application. So these are the wonderful options that is available when you're filing a trademark application. And I wish you all the best, all of you, in your endeavors to file a trademark. I hope you're all going to become very great trademark attorneys in future, and you get over all of these challenges. Any other questions?
No, ma'am.
Yes. I think it was a fantastic session. A lot of it have gone on right from, I think it's already close to 7:30 and we really did not realize the time. 1.5 hours has
Absolutely.
just
I'm
gone
just
by
saying,
and there
I was
was so
seeing the
much
time
learning.
just now.
Do you all agree with me? You can just type a yes if you all feel that there was a lot of interaction here today and a lot of learning on the subject of trademark, both in terms of filing as well as the enforcement bit of it. I mean, though given the paucity of time, this 1.5 hour was truly a capsule for us. Though a zero point
Truly,
0.5
truly.
mg, but a very strong dose of,
I would have liked
the
to have
trademark.
elaborated on the proceedings as Mr.
Yeah,
Saidi.
yeah.
Thankfully, he took up the whole thing and he started talking
Yes,
about
yes.
criminal proceeding and everything. I'm so
Sorry, ma'am.
glad.
Sorry for
No
interrupting.
worries at all. I'm glad. I'm glad. I was thinking we don't have much time, which is why I was ready to move on. I was telling EBC also that we don't have enough time to discuss on all of these things, which I would love to elaborate on because I have some real time, cases that are going on that are sub judice also, which I can discuss, but I can't put it in words. Which is why it's not on the PowerPoint presentation, but I can definitely give
Right.
you a lot of examples, but I don't have the time, unfortunately. Yeah,
I have a track record in the my district court Belgavi that I have taken 25 bails for non-bailable cases. That's
wonderful.
done in 2019. There's a track
That's
record.
great. That's great. That's great. Wonderful.
Yeah. All right. So thank you all. And should you be interested or if you have any questions relating to the trademark aspects, you can touch base with Gayatri. We'll be sharing her email address as well. So you could touch base with her sometime and get more professional guidance. But this is all for now. Yeah. And there's quite a bit of content, which will supplement your learning now. You can just go back to the reading material and the videos that have been shared with you regarding trademark. So that will sort of give you the solid foundation, trademark laws. Please continue the learning and we'll see you in the next week again. Yeah, with yet another very interesting subject of learning and a very, very experienced, attorney again. So next week we are going to have a session on copyright protection and enforcement, and I look forward to meet you in the next week. Thank you all and have a wonderful weekend.
Thank you. Thank you.
Thank you. Bye.